going to have a significant overlap in the subject matter of our presentations.
Really?
Yeah.
Oh, so it's on immigration?
No, it's not, but I mean, it's on like interracial relationships.
Mine is interracial.
Yours is it? Yeah.
Yeah. I mean, there's some. I mean, there is some, but I just don't know who the father of. I mean, in some way, I have no idea who.
It's a heavy door.
Yeah, I know. It's a hard door to get in. No, not at all. Come on in.
So when you're not our tech person, what do you do with the Immigration Center?
I'm not using all my tables. I'm the deputy director at the Center for Immigration Law and Policy here. So in the spring I teach an immigrants' rights policy clinic with Hiroshi. The rest of the year we have a team of litigators and policy advocates, and we are doing the work. Yeah, it's good. It's been a time.
Are you involved in Vascular Purdue?
Not on the case, but I worked at public counsel for 13 years or something before I came here. So yeah, spiritually involved in the case, but not on the litigation team. But yeah, and I have been doing some, again, not on the litigation team, but advising. We represent the NTPSA coalition of the Immigrant Protected Status litigation.
Oh, so you're doing that. So we were representing members of Congress on an amicus brief.
Oh, really? In NTPSA?
National
TV, yes.
In NTPSA one? Yeah, I've been on state counsel on that case, and it's been,
It's so hard.
Twice up to the...
Yeah.
but our team, he's doing the litigation, and then our team at the center developed a basic advocacy strategy after the district court win, where we ended up getting almost 95 people at custody.
Wow.
Period between, so it's,
Well, that's great.
yeah.
The difference that you made in your lives.
Yeah, so I feel like we're working at kind of all the different levels where we can, but it's a moment.
It's nice to meet you.
It's really nice to meet you all too. I'm really looking forward to the panel.
Thank you.
And so I will do my best to keep the tech on track.
Okay. Start. Okay, I think we're going to start. So thank you so much for coming to our session. I graduated from this law school 18 years ago, and I've never been in this room. So it's a new experience. I didn't know that this existed back here, but my name is Kaiko Matsumura. I'm a professor at Loyola Law School in LA. And I primarily focus on family law, and I teach 1L contracts. And I began teaching a seminar on Asian Americans in the law about 4 years ago, and through that work was invited to write a chapter on Asian American, trying to kind of put the experiences of Asian Americans into the family law canon, which explains how the two areas of interest came together. And in the process of writing that chapter, I came across references to the policy I'm about to discuss in this paper, which was called the mixed marriage policy, and dealt with the problem, in the words of the Western Defense Command, of what to do with people of mixed Japanese ancestry or people who were married to Japanese people who were subject to incarceration during World War II. So very few people have written about this. There's a published article by a historian, an unpublished history dissertation, a couple chapters in other people's work, like a social work book about World War II, and ethnic studies book. But so there is treatment of this topic, but not from the perspective of highlighting the evolution of a legal policy. I'm also interested in it simply because several of my family members were incarcerated during World War II, and I always thought of it as a Japanese thing, and so it shocked and kind of embarrassed me that I never thought about the fact that people were in interracial relationships, and so there would definitely be people affected beyond Japanese Americans. And so I went to the National Archives last winter break, collected documents, have been going through War Relocation Authority archives, a lot of which are online. And over the summer I started writing the descriptive part of this paper, which is just describing what the policy is and how it evolved. And I feel like I'm about 80 to 90% done with that descriptive part. I wish I were further along. But then, you know, where exactly it goes, I'll show that I have some initial thoughts, but I'm really open to hearing feedback from people, what you all think is interesting or important. So maybe go to the next slide, thanks. So just really quickly, at the break of World War II, we know that there were a little under 120,000 Japanese and Japanese American people who were subject to the exclusion and incarceration orders. But at the time, there were about 1,400 Nikkei, I'm using that term to describe both Japanese and Japanese Americans, who were in interracial marriages, and approximately 700 to 900 people that they called mixed blood at the time, so, you know, mixed race, people of Japanese ancestry who were potentially subject to the orders. So next slide. So initially, the Western Defense Command, who were delegated authority to manage the program of internment and incarceration, thought that they would just make everybody who had any drop of Japanese blood subject to the exclusion order. But the powers that be, I'm speaking specifically of Lieutenant General John DeWitt, who was the commander of the Western Defense Command, and his deputy, Carl Bentinson. They immediately recognized that there were going to be several problems posed by what they call mixed race and mixed blood families. So one problem is that it would result in family separation, and it was a stated goal, and I do believe that they intended not to separate families when possible. I mean, they didn't ultimately care that much about it, but it was a goal. That they also felt that pursuant to the policy, they would have to let family members who are not Japanese accompany their Japanese family members into the camps. And they also thought that some of the people who were subject to these incarceration or exclusion orders just weren't good fits for the evacuation program in the first place. They were not culturally Japanese, they didn't look Japanese. So there was a feeling that there was a category error being committed if they were strict about the one drop rule. So we can go to the next slide. I'm trying to go through really quickly so that I finish this in 10 minutes. So early after Executive Order 9066 was announced, and Japanese Americans were being made aware that they would be subject to this incarceration, family members immediately began to petition, or affected individuals immediately began to ask, like, what's going to happen to me, basically. And so during this period of time, people were subject to very inconsistent messaging. Some people were told, because of their family relationships, that they wouldn't have to report. Other people were told that there would be no exemptions at all. So there was a lot of panic in this time period. This is an excerpt from a set of emails by the Alameda County, someone in the Alameda County, just writing to military officials, describing some concerns that people in that area had. And as you can see, this person who was a mixed blood U.S. veteran said that if he was forced to evacuate, he would kill himself. So in response to this uncertainty, including letters to the President of the United States, the First Lady, the Secretary of War, anyone really with any influence, the Western Defense Command leaders promulgated a policy that they called the mixed blood or mixed race policy. So it's the next slide. And so in this time period, they came up with different categories. They were trying to kind of work out behind the scenes different categories of people who might be exempted from the evacuation orders. So this took place in June and July. It was top secret. They didn't want anyone to know that they were considering exemptions. I think the main reason is because they didn't want people to ultimately know that there were Japanese people back on the West Coast. and they didn't want to give false hope to people who might end up being incarcerated. But so the next slide shows the initial mixed marriage policy that they came up with in early July 1942. And so you can see that they're basically different categories of individuals and families who would be exempted from the orders. And so if the policy made distinctions between whether the husband or wife was Japanese. If the husband was Japanese and they had minor children, they would be able to leave incarceration camps, but they would have to go east. They couldn't return back to their homes on the West Coast. If the husband was white and they had minor children, they'd be able to return to their homes in California, Washington, etc. If they did not have minor children, they were not subject to any exemption. If they were mixed race individuals of 50% or less Japanese blood, and they could show that they lived in a Caucasian environment, they would be allowed to come home. So there are these various kind of classifications made. So what I want to do in this paper is show how there was an evolution of this policy. It's not necessarily static, it's evolving. And I want to kind of draw lessons from how it evolved. So there were several kind of very interesting revisions to that initial policy. So the first set of revisions had to do with non-Japanese husbands. So specifically Filipino and Chinese men. There were many interracial marriages where the husbands were Filipino or Chinese, and they petitioned to be covered by the policy. It only took 1 month for them to be included. So they changed the Caucasian husband requirements to husband of a friendly nation, but didn't change the requirement that the children be raised in a Caucasian environment, which is just sort of interesting in and of itself. Like, how do Filipino husbands raise their kids in a Caucasian environment? So the second major revision had to do with child-free marriages involving white husbands. So white husbands were very aggrieved by the fact that they couldn't take their wives out of the camps. And I think this is really particularly interesting because they expected that they would be able to kind of exercise their prerogative and kind of unify their households. And so they faced massive resistance from the Western Defense Command, but they had an ally in the Assistant Secretary of War. And so there's a behind-the-scenes fight that goes on for close to a year. At the end of it, finally, white husbands of child-free marriages are able to bring their wives back to the West Coast. But it really took the replacement of General DeWitt for that to happen. So actually, that's the next slide. There are a couple other interesting changes that are also there. So Korean husbands were treated like Japanese because Japan had colonized Korea, and so they had to separately fight for their exemption even after the Chinese and Filipino husbands won the freedom of their spouses. So I think the interesting thing in the way that white husbands argued their case is that they shifted from arguing that their families were loyal, which was an initial basis to kind of claim an exemption. When that didn't work, they really reframed their arguments in terms of the deprivation of their prerogative as husbands. So you see in this letter, Ross Kusian argues that basically because he might be drafted into the military and he has an aging mother at home that he has to take care of, he really needs his wife, but it's not because he loves her. I mean, he does love her, I think, based on the documents I've seen. But the argument he makes is that this would, you're taking me away, nobody's there to care for my mother, and my wife would be the person to do that. And so it's interesting to see how those arguments transformed to try to attain the policy objectives for these people. To sum this part of the exemptions up, I would say that what emerges, I think, is the motivation for the incarceration, especially on the part of the architect, General DeWitt, is that there's no such thing as a loyal Japanese. And I think he honestly believed that. And so if disloyalty is a racial trait, what I think is interesting about the exemption, the fact that some mixed and full-blooded Japanese people would be allowed to return to the West Coast, is that in some way there's a racial transformation, that they have become non-Japanese in a meaningful way to allow them to escape the incarceration. And so, if we can go to the next slide. There's a flip side to this, which are the family members who did not obtain an exemption. And so, the military never intended to disallow non-Japanese family members from joining their family in the camps. And so the way they did this was through a form that looked like this, which was very contractual in nature. A person was asked to identify themselves, identify their racial identity, their family relationship to the incarcerated individual, and basically they signed a form that's witnessed that says that the person who's applying consents, is requesting the privilege of joining their family member in the camp and consents to be treated as Japanese for all purposes related to the incarceration for the duration of the war. And so, if we could just go to the... So, I think what's interesting about this policy is that we're seeing some people through their family relationships are becoming white or at least non-Japanese in a meaningful sense, in a legal sense, in terms of legal entitlements, while simultaneously other people who are non-Japanese are becoming Japanese in a legal sense. And so there's a racial transformation going in different directions here that I want to explore. And so I think, and given my interest in family law, I'm particularly interested in how family relationships affect racial becoming, the trajectories of people in their racial experiences. I will note as an interesting postscript to the previous slide that there was one woman who joined, a white woman, she joined her husband in camp for the duration of the war. After the war, Congress passed an act allowing people whose property had been destroyed or lost during that period to bring claims for their property. She and her husband filed a claim, and when it was adjudicated by Warren Berger, who was then an acting assistant attorney general, they discounted the claim by 50% because it's community property. And they said, well, because you're white, and this is a statute allowing Japanese people to recover, that we have to take half the value away from you. She said, well, I consented to be Japanese for all purposes, and I lost my liberty for 4 years, and they denied her claim. The interesting thing is they accepted that argument by one person who was in there with her family, but they had minor children. And they distinguished that case and they said, well, because that woman had minor children, she had no choice but to go to the camps. But you willingly went to the camps with your husband. And so that's a reason to distinguish between your two situations. So there's a lot going on that I have yet to unpack, but I'm very interested in the way that family relationships are affecting racial experience. And I would say the one other thing that motivates me is I still think to this day that there are different one's experience and one's proximity to whiteness as an Asian American today is affected by gender in a way that I think is not, people have written about that, but I think it's not fully explored like in this context. And so I'm hoping to make some claims here that are at least relevant to what I think might be going on today. So I'll stop there.
So the way we've structured this, right? Like we do comments for you.
Right, but I used up 16 minutes. So.
Oh.
Well, we can have 5 minutes of
Okay.
discussion.
Yeah.
Yeah.
Okay.
You want to do that?
Sure.
Even more than
Well,
that. We have time
yeah.
at the end. So
Yeah.
just
Yeah. Because
There's a question.
Clarification question about, so you mentioned Caucasian environment.
Yes.
Was that defined in the document?
No. No, it wasn't
We're just
defined.
gonna go with
Yeah.
the vibes.
That's right. And actually, that was the basis to extend it beyond white people, because actually, I mentioned that Filipino and Chinese were the most common non-Japanese husbands. Actually, they were even more common than Caucasian husbands, but there were also people they called Mexican, they were Native American husbands, and so there was one black husband, and so I think they decided rather than defining Caucasian, they would just open it up to husbands of friendly nations. That saves them the problem of having to figure out whether a Mexican husband is a Caucasian husband.
I don't know if you have a title yet, but I don't know if you're familiar with the 1980 song by the Vapors. I'm turning Japanese.
Oh yeah, turning Japanese. Yeah.
Just if you're looking for a title. I was curious about whether the gender dimension of this, including primarily was it when the wife was Japanese and the spouse was white, Chinese, Filipino, or Korean. What about the other way? Were there parents when the woman was white and it was the Japanese man? Like the gender dimension, especially because of the way the 1907 Expatriation Act operated, where if a woman, U.S. citizen woman, married an alien man, she lost her citizenship because. So I just wondered whether there was an asymmetry in what you observed.
So the policy treated non-Japanese wives of Japanese husbands much worse, right? And and it was much more common at the time for interracial marriages involving Japanese to have Japanese husbands rather than Japanese wives. It was like a 2-to-1 kind of ratio. And those people frequently, because of the gender, like access to work opportunities and things like that at the time, the families that remained in the camps were much more likely to be Japanese husband-headed families, and so we do have, several white and other non-Japanese wives and their children in the camps, and technically, if they had minor children, they'd be able to leave, just not come back to the exclusion area, right? But many of them felt like they didn't have any means to support their families if they went to Chicago or Iowa or whatever else, and so they remained in the camps. And so the people who remained in the camps, the families were, the non-Japanese people who were related to Japanese people in the camps were mostly, they had Japanese husbands/fathers. Yeah.
So this is 1942. Were a lot of the couples, mixed race couples, how did they get married? Because the Perez case didn't come until 1948, right? And then Loving was 1967.
Yeah. Well, they mostly married in Washington or Mexico. Is what I think, or some states without anti-miscegenation laws, because California would recognize them, they just wouldn't perform the marriages. And so it's interesting, I mean, when you look at the statistics, it's like marriage records in LA County, for example, which was the county where there were the most Japanese Americans living at the time. There are very few records of a Japanese person married to a non-Japanese person there, right? But then when the War Relocation Authority is doing a census of the people who are subject to its orders, they're finding thousands of mixed marriage and mixed blood Japanese people, and I think that's because probably there's a lot of evasion, and you only realize it when you are rounding people up and kind of putting them in one place, that you see the numbers.
I had a question about, there was one slide that you had that talked about sort of, I guess, not speaking the Japanese language, and I wondered if there were any other statements that were in the documents that you researched that spoke to, I guess, their political affiliation or their religion, or was it just about speaking the language?
They looked at who you were friends with, like who you socialized with, whether you spoke Japanese at home, what religion you were in, and another big one, even above religion. Religion only came up in a few of these case studies, but your diet. You know, what, like they kept track. Is it a 50% Japanese diet, a 100% American diet?
Wow.
So I think the first thing they would look at is language spoken. Probably the second most common thing is like who your friends are, and the third most common thing was diet.
That's interesting. Time. Oh.
Great, thank you.
Thank you. Who's next?
I thought you were.
I can go next, it's fine. I thought she was pulling up your things.
She's gonna pull it up, but,
You said you sent it to me?
Okay.
yeah, I
You
just
sent
sent
it to
it.
the
Oh,
email?
okay, okay.
Yes.
You
wanna
want
go
me to
next?
call?
I can go.
Okay.
You wanna start, or you wanna
Yeah,
start,
sure.
Jessica?
I
and
can
hopefully
go.
it'll come in?
Yeah.
Okay. Let me pull up your slides then.
Here.
I do have some animated slides.
Oh,
so
boy.
I'm
You guys are really
I'm
challenging.
sorry, I thought I would have a clicker, but I'll tell you.
She just gets people out of immigration
I know.
lockup.
That's challenging apparently than this endeavor. Thanks for your patience, everyone.
Yeah.
See?
Okay.
we
Oh, yeah,
abandon
you
you
can
and-
abandon, yeah, you can
I just
abandon
wanna be
me.
able to see, it's hard to see typos.
Okay, I'll wait till they move. Oh, well, I can start talking. I'm up here by myself. No, it's fine.
And I can take a picture.
So I'm probably going to read a little bit just so I don't go off script, because if I go off script, I will definitely take more than 20 minutes. My ongoing work in progress is called the Missing Marriage Case, and it is about the case in the matter of the estate of Basil Campbell, which is the certificate of proof of will to my right. The family law canon is missing several cases. It lacks historically significant and culturally relevant scaffolding offered by cases involving enslavement laws and their impact on subsequent developments in the field. This article fills a gap in the literature by introducing In Re Estate of Campbell, a redemption-era probate suit filed by two formerly enslaved sons seeking to inherit part of their wealthy father's estate. Basil Campbell was a rich, quote, Negro, and his sons were part of a significant group of Black adult children in the late 19th and early 20th century who attempted to legally establish their right to inheritance and family integrity through probate courts. The article argues that In Re Estate of Campbell should be a core case within the family law canon. This case offers a rich tracing of an American family tree that includes both African American and white family members. The tracing of family for descendants of enslaved persons proves to be difficult for a variety of reasons, but the primary two reasons are that, one, slavery laws documented enslaved persons as property rather than human beings, and two, enslaved persons were forbidden from learning to read and write, so they could not document their own family history in a way that could be recorded. Basil Campbell's biographical information is more readily available because while he was once considered property, he was able to eventually own a diverse portfolio of property and write his own story. By becoming a wealthy landowner, investing in business stock, and becoming a political figure in California, Basil's life was well documented in California records and Negro newspapers circulated throughout the country. This case makes several contributions to both the doctrine and pedagogy of family law. First, it demonstrates how slavery law is as core as the common law to the family law canon, because it established the structure, status, and identity for Black families, which comprised a significant population in America during the 17th and 18th centuries. Slide 2. Oh, sorry, it's not okay.
Tricky.
One of the most distinguishing features of Black American families is that for most of the nation's existence, enslaved persons could not legally marry and did not have the right to family integrity. Contemporary Family Law, 6th edition, which is the book that Kaipo and I both are co-authors on, is the only family law case book that includes a case about enslaved families in America. While other family law course books may mention slavery or even include excerpts about how slave families existed outside of the law, There are no case books that include how the law shaped the status, structure, and identity of slave families. This is not Basil and his family. It's just a picture of, you can't really see it as much. It's a picture of a white family in front of a plantation home and a black family in front of a shack. And so there's obviously a stark contrast between the photos with respect to what would be considered the wealth, the main source of wealth for families, which was the family home, plantation versus the slave shack, and even in this case, the shack would be owned by the master. Slide 3. So the Campbell case explicates the opposite treatments of enslaved families and their descendants, illuminating intersections between fundamental constitutional freedoms, including the right to contract, the right to marry, and the right to have and raise children. This is the first law review article to provide a descriptive review and a prescriptive analysis of this case, arguing that it is a missing yet critical part of the right to marry cases in the family law canon. It asserts that the laws which explicitly excluded Black people from normative family law doctrine created a bifurcated racial legal framework that is still reflected in the pedagogy and practice of family law today. Slide 4. This is Basil Campbell, very handsome man. He was born in Missouri on March 9th, 1823, He was an enslaved person owned by James G. Campbell, who might have been his father, but there are no records to show who his father was, but it is at least testified to in the testimony of the case that his father was likely white. In 1836, when he was 13 years old, he was sold to Joseph Stevens for $700. Mr. Stevens died a year later, and between the time that his estate was settled, he was hired out via auction to the highest bidder for several years. In 1842, the estate of Mr. Stevens was divided among his heirs, and Basil was purchased by the widow of Mr. Stevens, who was Catherine, for $450. Later on, he was sold to her brother, J.D. Stevens, for $1,200. In the interim, he became basically the foreman of the farm that Catherine Stevens inherited from her father. And so he often also raised his own pigs and own food, and he was well known for being a good farmman. But he basically ruled over the other enslaved persons who were on the farm alongside him. Next slide. So this is his estate in California. Once he moved with J.D. Stevens, who purchased him, they moved out to Yolo County, California, which is right outside of Sacramento, and they became cattle herders, steelmen, and so he eventually actually negotiated, before they left Missouri, he negotiated with J.D. Stevens to purchase his own freedom. And he negotiated 10 years, $100 a year. He ended up purchasing his freedom earlier or sooner in 7 years, because he must have been saving his money from some of the things that he was doing back in Missouri. So once he purchased his freedom, he then began purchasing property. The history of J.D. Stevens shows that he was a teacher, and it's likely that he taught Basil how to write and read. And so he became a landowner. This is a picture of his land that's in the atlas at that time. And so he was very well known. He was one of the wealthiest African Americans in California, and he owned almost 3,000 acres. And so in addition to them sort of maintaining their relationship, their friendship, some of the things that he owned were stock in the first bank, which was owned or co-founded by J.D. Stevens, as well as a grains company called Madison Warehouse Company. And so he ended up buying stock in the companies that J.D. Stevens co-owned or co-founded. And that was part of what he gave away in his last will and testament. Is this slide 5? Maybe next slide. So this is the family tree of Basil. He was initially married to Mary Stevens, his first wife pre-emancipation, and they had 2 sons, G. Wyatt and John W., who were the petitioners in the probate suit. Once he purchased his own freedom and moved what they would call out of country, he ended up marrying Rebecca Dalton, who was his second wife. She had a child, Lenora Williams, who he adopted. and who also was a beneficiary in his will along with her husband and 5 children. I'm sorry, yes, her husband and 5 children. The third wife was Mary Jane Campbell. Rebecca died. They didn't have any children together, and he didn't have children with Mary Jane Campbell either. When he married her, she was probably 28 or 30. I think when he died, she might have been 35 and he was 75. So older men do get younger women even back then. So, his wealth obviously was something that was attractive to the women in the community. But this is the family tree. So the question in the case, you can make next slide. The question in the case was really about whether their slave marriage could be legally recognized. And so they were coming to dispute the will and to say that they should receive at least 1/3 of the estate. And so technically it was important to be able to answer this legal question to determine how to distribute Campbell's estate, whether they would be presumptively legitimate heirs. But the conclusion of the court that there was no marriage proven between Basil and Mary Stevens. And so they looked at the conduct of the parties after the marriage. Mary remained, she did not remarry, even though her first husband was sold away, and she remarried with Basil after marrying her first husband and having 3 children with the first husband and 3 other children of unknown fathers, but those fathers were white men or known to be white men, but just not identified. And so those were the last 2 children that she had, John and G. Wyatt. They said there was no statute in evidence to prove that they were married or could have been married during that time. The court spent a lot of time looking at, whether slave marriages could exist legally. And so the next slide sort of goes through that. Wait, hold on, not yet. And they did look at Basil's, what he did after the marriage. And so he got married twice, as you could see from the previous slide. And that, so when you marry after, there was no such thing as slave divorce at that time, but basically the presumption of marriage based on cohabitation and reputation that would have been allowed for slave marriages. They said that his subsequent formal and lawful marriages in California would basically remove that presumption that he was married to Mary Stevens. It's a little confusing because he was married to 2 Marys. Next slide. All right, so you can just click, it's fine. You can,
keep the whole.
Yes, so the concentration in the case was on, really was the treatise on marriage or common law marriage, but also indicated why legal marriage between enslaved persons was not legally recognized. And so the reason why I thought this case would be great for the casebook is because it explicitly goes through these and distinguishes between, what was allowed, in common law marriage and what was not allowed for slave marriages. And so it was really about whether, these 2 people could enter a contract, and because they were enslaved persons, they could not. And so marriage was a civil contract. They were incapable of entering into it. They were rendered property, and so therefore could not consent to anything without their master or mistress. They also talked about the duties of the husband and the wife being incompatible with the duties of enslaved persons owed to their master. So they could not do what would necessarily be done because all of their duties were to their master. And then the last thing they talked about was the slave's acquisitions accrued to the master. So anything the slave would have really was his master's. It did not belong to him, which would include the children as well. Next slide. So ultimately, the characteristics that are explicitly stated in the case is that slave marriages were like tolerated concubinage, and so it was temporary. It was a marriage of convenience. The testimony was that men had the privilege and could quit whenever he felt like it. They had the legal right to marry again if one was sold away from the other or left and went clean out of country, and that there was no such thing as slave divorce. And so it explicitly shows that, African slaves or enslaved persons who were brought to America were legally denied the right to marry. They obviously had traditions of jumping the broom. One of the pictures was that signified their seal of matrimony, but ultimately they had no control over their married life or what happened to their children because often when there was a death in the family or there was debt, there was typically forced separation of families by slave masters. And so there was an inability to protect their wives or their children from being sold away from them. And particularly when you think about or look at some of the arguments that the petitioners made in order to keep their property, one of the claims was that Mary was lewd, that she slept with all these different men and she had all these babies by different fathers, and so she could not be married because of that. And so it was interesting because that was the argument of a black woman and her black child against another black woman. So utilizing the same stereotype that was used in order to justify rape and sort of how women were exploited and black women were exploited and taken advantage of during enslavement in order to maintain their asset. So that was a very stark and real takeaway from looking at the briefs that were filed by the attorneys. Next slide. So interestingly enough, McMillan versus Greer, which is the 1927 case, overturned the Campbell case. There was an argument made by the attorneys for John and G. Wyatt that Civil Code Section 1387 applied, and it was a section that basically changed the status of children who were born of void marriages. And so it dealt with all children, but it did include children who were born during enslavement. So it made the issue of all marriages null and law legitimate. So technically, had they dealt with that particular section that was argued correctly, then the children would have been declared heirs. Obviously, even though it was overturned, it did not change the outcome for Basil's sons. They basically, it demonstrated how judges and courts, in the decision of the judge in this case, even though there was one dissent, that they were key vehicles in reinstating, the laws of enslavement even 40 years after emancipation. It also demonstrated how different states didn't have the same law. So there were some states that had this type of law, the Civil Code Section 37, and other states that did not. And so depending on where you live, there were inconsistencies with respect to whether a child would be deemed an heir or not. And so that meant that there were inconsistencies with respect to family law status and identity. It also demonstrates that the black-white wealth gap began much earlier than the 20th century. And so most documentaries will talk about the GI Bill and how that was done in a very discriminatory way, but this shows that, especially because it was a black father, that blacks during the Redemption era did have significant property. This is not the only case. There are several cases, I dare say there are probably hundreds of cases where there might have been smaller amounts of property, but property nevertheless, where adult children were trying to become heirs and to inherit from two black parents, not just a person who was an owner where there was a mixed race relationship, or in some cases rape. Next slide. So this was inheritance thwarted. Okay, thank you, 3 minutes. All right, so I'm gonna go really quick. From a broader federal family law perspective, family law doctrine does not really encapsulate the historical legal treatment of black families. It neglects the stories of enslaved families whose freedom was made possible by the passage of the 13th, 14th, and 15th Amendments. And so the constitutional implications of slavery law are really not mentioned in most of the family law textbooks, as I said earlier. So while most students understand that the original purpose of the 14th Amendment was to provide citizenship rights to formerly enslaved persons, the extent to which they did not have any human rights is blatantly overlooked in the family law canon. So the Campbell case squarely addresses the heart of marriage as a fundamental constitutional freedom of the right to contract. The other thing I would say, this is the plot of Basil Campbell. He purchased this plot, which is very unusual. He had spaces for 12 people. I can't go into more detail, but these are his granddaughter and great-granddaughter who favor him significantly, if you remember what he looked like from the other picture. But these are the children along the John Wheeler or John Campbell line. Next slide. Okay, you can just keep going because this is the one. Okay, so I want to insert this case because it does give a new narrative in the family law canon. I mean, primarily that the laws of enslavement were directly opposite that of common law, so there was this dual system of family law operating at the same time, which obviously maintained the enslavement with respect to children who were born in enslavement. But it continued the separation of Black families even after emancipation. Interestingly enough, John and G. Wyatt included the history of enslavement in America, and they used it to establish their rights to family recognition. So it was the first time I'm reading like this history of like basically the slave trade and tying the slave trade to the laws in Virginia and the laws in Missouri. So it's a very interesting argument that they made that I'd never seen before. It also sort of deals with the adoption of, like I mentioned before, the white stereotypes of Black women by Black women to maintain their assets. On the side of status structure and identity of Black families, it introduces really something that's outside of the norm that's in family law cases. So this is Black women and women did value marriage. They did get married. They were not all poor. Basil was a wealthy business owner and a state politician, so it disrupts the poverty stereotype that often is presented in family law. And then it also deals with some maybe things we haven't dealt with before, which is the acceptance of pre-emancipation bigamous family patterns within Black families. So the leaving of one wife to go with another wife without any kind of legal paperwork because it was not necessary. It really was part of the pattern. And so that really hasn't been researched or written about in a legal context. And I know I'm at time, I have 1 minute. It also deals with the embracement of step families and adoptions much earlier in America than previously noted. And so Basil actually adopted Lenora, and there's other information in some of the Negro newspapers that he adopted another woman. And so because he was wealthy, he was able to sort of take care of more people in his family than others. And that's it. All right.
That's okay. That's all right. No, it's fine. Thank you. I just wanted a few pictures anyway.
Okay.
Yeah. Thank you.
You have pictures too?
Yeah, but I'm just going to use my laptop.
Okay.
Hi, good afternoon, everyone. My name is Rose Quizan-Villazor. I'm at Rutgers Law School, and I am here to present a book project that I've been working on for quite some time, and I really need to finish it, but there are other things that
Our other book.
we have another book, and we bumped up our deadline, and so I was able to bump back or down my other deadline. But this is it's one of my favorite projects that I've been working on for some time, and I'm really excited to be able to get back into it, ultimately, once we finish our book. So, I'll just show you, this is the title of my book. I think it says, Forbidden Love, Race, Citizenship, and the American Family. It is a book about 3 Japanese and Japanese American women and their different partners that they've been with in Japan and in the United States. The book focuses primarily on Japanese families in Japan who had connections with U.S. Citizen soldiers or U.S. citizen civilians. And so in some ways, Kai, was the other side of, you're talking about the stories of Japanese Americans within the United States, mixed race marriages, and I'm focused on mixed race families, Japanese American families outside of the U.S. And part of my claim is to be able to show that their stories are part of the Asian American story, part of U.S. history. We often think about Asian American studies and Asian American legal history as centered within the boundaries of the United States. And one of my core arguments in the book is to expand what we mean by Asian American studies and Asian American legal history, to go places where the United States had empire or military or through empire colonization of places outside the U.S. And so I know it's really hard. I'm sorry, I didn't think about sending this earlier. These are three women who are, the top woman is Helene Emily Boyce, and she's a Japanese woman, mixed Japanese and German, under U.S. law because of the mixed blood restrictions under immigration law. She was 50% Japanese and 50% white, and so she was Japanese for purposes of U.S. immigration law, such that when she landed in Seattle, at Seattle, and she tried to enter the United States, she was detained and ordered deported. I'll tell you more about that story, but I'm just kind of previewing, giving you a preview of who they are. Oh, I'm sorry, may I have 12 minutes, please? So sorry. And then the one in the middle is her daughter, Vivian Wilson. Vivian is, her father is also white, and so she was also 50% Japanese and 50% white under both, under U.S. law. And then the last woman, her name is Marion Vaughn, and she is, for purposes of U.S. racial categories, she would be considered 75% white and 25% Japanese. Okay, so why does it matter? Why am I writing a book about race, citizenship, and the American family? Part of my claim in the book is to talk about how we normally don't think of immigration and citizenship laws as part of the canon of family law. Through my work as an immigration legal scholar, I've written about how immigration and citizenship laws have led to family separations, have restricted interracial marriages, restricted marriages across borders. Immigration and citizenship laws historically, as well as today, have prevented the flourishing of families. And so the stories I'm trying to show in the book highlights the role that immigration and citizenship laws have played in family formation, family structures, and family cultivation or flourishing. For today's talk, I wanted to talk about the third woman. Her name is Marion Vaughn. She was the subject of a private bill that was passed in Congress in 1950. Her mother, Vivian, was married to a U.S. citizen civilian by common law. When her father was in Japan to work for the military, he wanted to marry Vivian. They sought permission from the U.S. government, particularly the military. The military had restrictions kind of similar to the types of policies you were talking about, Kaipo, on the U.S. side. The U.S. military, as applied in Japan and Korea and in the Philippines, said that only under exceptional circumstances can U.S. citizens marry persons who are ineligible for citizenship. And that's key, because if you're not eligible for citizenship, you're not allowed to enter the United States at this time. This is in 1945. Japanese at the time were still ineligible for citizenship. They would not be eligible until 1952. So this policy said that a U.S. soldier or civilian may obtain permission to marry if the person is eligible for citizenship. So by default, the law prevented U.S. soldiers or civilians from marrying Japanese women because they were not allowed to enter the United States because they were racially barred from citizenship, right? So Marion's parents ended up having going through a civil ceremony, and they lived as husband and wife. And they suffered discrimination because they were mixed race. And so Marion's father decided to go back to the United States and find a way to bring his wife and child over to the U.S. At the time, the War Rights Act had been passed, which gave war brides and grooms the ability to have an expedited admission to the United States. But Japanese were precluded from the War Rights Act because, according to the laws and a case and a policy at that time, Congress did not intend to allow Japanese nationals to enter the United States, even if they were married to a U.S. citizen under the War Rights Act. And so still, Marianne's father found a way to go to his U.S. Senator in Nevada, Pat McCarran, and Pat McCarran ended up sponsoring a bill that passed Congress that allowed Vivian, his wife, and his daughter to immigrate to the U.S. On the same day that the bill was passed, Vivian died in Japan of tuberculosis. And so there's a whole other story about what happened to Marian. I'll just fast forward a little bit to say that she ended up being raised by her Japanese nanny who absconded with her, which meant that she was, she never got to meet her father. She never entered the United States. And so that story highlights for me the law, how law separated families, particularly mixed race families during this era between mainly Japanese women and white US soldiers or civilians. Recall that I mentioned that there is in the policy, except under exceptional circumstances. And that meant that if there was a US soldier, a US American soldier who's Japanese, the US military allowed them to get married because there was no violation of mixed race policies, right? I mean, but when it came to white American soldiers and civilians trying to marry Japanese women, those types of permissions, those requests were denied. And so the story that I'm hoping to show here is how immigration and citizenship laws separated families in ways that we don't fully appreciate. We see that a lot today at the border, and how families end up being separated not only because of deportation, but because a spouse would be considered inadmissible to come to the United States, right? Which has led to children not being with their parents. And so, but that story that we have today actually we can think back to the 1940s and how there were many Japanese American families who were separated as a result of similar policies. And so why does it matter? Well, I think it matters because for at least two reasons that I'm exploring in the book. One is a story about Asian American history here, to me, is important to be told. That there were, we've talked about how Asian Americans have been, so Neil Gatanda's here and Bob Chang's here, so they've written on the perpetual foreigner stereotype of Asian Americans. And this, to me, is a story of how that perpetual foreigner stereotype is part of that story. And second, I want to show the through line of citizenship and immigration law as belonging within the canon of family law. It is equally important to see how these laws about the border and about what it means to belong in the United States is a very critical part of family formation in the United States. And that should help us to inform how we think about what constitutes family law and what it meant to be an American family in the United States. So thank you.
So we have time now for questions. I mean, so we were given choices. We have 20 minutes and we can allocate it. So she took 12 minutes to present, so there are 8 minutes now for conversation. If you're puzzled, like what?
No, I just wanted to know, because based on the title of your piece, or the book, is it going to be just sort of general, talking about race, American citizenship, and then focusing on the 3 women that you highlighted, or what's the setup of it?
Yeah, no, that's great. I use the 3 women, so the first woman, Helene, I have 2 chapters about her, and then her daughter Vivian is also 2 chapters, and then Marian occupies 4 chapters. And the reason why Marian's still alive and her story continues to be told, the reason how I got interested in this project is I wrote a law review article in 2011. It's so old. It was one of my, I was still pre-tenure at the time, and it got published at NYU Law Review. It got picked up by Jotwell, and then Marian read it a year later, And she contacted me and she said, "You wrote about my grandmother. I have to tell you more about my mother." I didn't know anything about her mother, Vivian. So, and then she asked, "Do you think I'm a U.S. citizen?" And so I ended up representing her as a U.S. and I helped get her citizenship. So this kind of her story is this through line of citizenship as both about inclusion and exclusion. So she has 4 chapters because I talk about how she was raised in Japan instead of coming to the U.S. And the last 2 chapters about what it means for her to be considered an American, formally and maybe also substantively. Hi, Chris.
Hi.
You've heard this before.
I have.
But you didn't hear Marion, so I talked about her grandmother.
Yeah, but I'm still like fascinated by it. And so my question is, how are you approaching crafting the narratives in the piece? And like, yeah, so like, how are you approaching writing just the stories? In one way is a basic question, and then specifically, how are you structuring the narratives in the context of the book, which obviously is going to be different than how you think about it in a larger context?
Yeah, there's so much freedom, I think, in writing in a book because I don't have to put footnotes for every single dang sentence, right?
Yeah.
And yeah, so there's freedom, but then now that freedom kind of gets in the way of my own writing because the way I was trained was to write law review articles.
Yeah.
And so it's a great question about the narrative, the stories. What I've done, at least with Marion, is to interview her and her other family members who are still alive and incorporate the dialogue, the stories into the book itself. So what I hope to do is use their experiences and highlight their stories and then weave in the laws of immigration or citizenship law or military regulations throughout the book. It is a challenge for me because either I could write a book about the laws and then use them as my examples, or flip it, right? Flip it and say, here's Marion, she was left behind in Japan, and let me tell you how that happened. And then I go and talk about these are she was her mother's racially inadmissible. Her mother couldn't marry her dad. And so she was born a non-marital child, and that made it harder for her to then enter the United States. So that's how it's structured right now, stories, and then using their story to tease out the different laws. Ida, and then who's gonna? Oh yeah, okay, because you were helping me.
I clearly not helping well enough. I have no idea why it didn't arrive there. But I'm actually curious about the overlap, if there is any, between what you're looking at and Kaipo's research on what was happening within the United States, and whether there's any evidence of any kind of conversation or thinking about folks the folks in the Department of War who were thinking about the incarceration plan, and whether they were looking to the immigration laws and the citizenship laws to help them either define how they were parsing people out there, and whether there was any whether that was bi-directional. In other words, like, was what was happening and how they were defining race and Japanese identity in the incarceration context, is there any kind of evidence that that's sort of influencing how the citizenship laws were either being developed or implemented during that period?
Yeah.
I can go quickly in there.
Yeah.
So the short answer is I think that the people who were making the decisions about this policy were in a bubble, and so they were not super aware of they did seek out one legal opinion about the status of like American women who married Japanese national husbands. And so there's one instance in which they kind of wanted to know the implications of that. But for the most part, the policy they designed, I think, was just for the population that they were targeting. That doesn't mean they weren't influenced by broader understandings or anything, but I think they were just, they weren't sophisticated. They weren't hyper-focused. They were just like looking at this problem. But I will say that I neglected to say this in my response to one of the reasons that there were also a number of mixed race families is because there were a decent number where they just immigrated from Japan. So they entered into interracial marriages in Japan and then immigrated to the United States. And so that's another source of these people, in addition to people who try to marry in the United States. And that's where you get more like, you know, Julius Downs was 5/8 white.
Yeah.
And how could he get that way in, you know, you can't get that way in only one generation, right? And the fact was that there were like 3 or 4 generations of intermarriage in Japan starting in the 1850s that led to, he's just one example of the types of people. So some of those people had come in and then they were swept up in the US's incarceration program.
Yeah, so I would love to see that connection between our projects. I'm thinking of Sonia Gomez's work on Birthright Act, Picture Brides and War Brides, because I wondered if, so her, I'm sorry, I just like, all of a sudden, hold on. Because you're right, the military policies are kind of in a bubble. The policies that affected the people I'm writing about, it applied in the Pacific Theater, right? But at some point, I imagine that they would have talked to each other, and Sonia Gomez's work might be helpful in connecting our projects.
There were 2 other hands out there.
Hi, I had a question for Jessica. Thank you so much. I really learned a lot about this history that I hadn't spent a lot of time thinking about. I wanted to just make sure I understood things and then ask a little bit about like some of the words and labels that you use. So my first question is, when Basil is married to the first Mary, Mary is a slave.
Yes,
Basil is a
slave.
slave. Okay, so he has not bought his freedom
No.
yet. So that was my first question. I just wanted to get clarity on that. But here are my questions about words and labels a little bit. At one point, I think you used the word bigamy, and one of the things that I was thinking about is, you know, right, is it bigamy? It depends if that's actually a legit marriage to begin with, right?
Yeah.
But bigamy sometimes we use to mean not just like being married to someone else when you're trying to get married to a new person. It also often is about like simultaneous like polygamy. You know? And he is really a serial, well, I don't know, monogamous.
Monogamous.
Right?
Well,
Yeah.
arguably, I mean, I think when John and G. Wyatt present their case, they say, our mother was still married to Basil. She never got married again. And so she always said that he was coming back to get us and purchase our freedom and bring us to him. And there is testimony where he came back and he and John had a conversation and he asked about Mary and the other son who were then in Texas. And so there was an acknowledgement that he knew they were his sons, but because there was no such thing as slave divorce, he didn't have to get divorced from her to marry the new woman or his second wife.
Right. But
So,
for
yeah.
all practical purposes, functional behavior, they were no longer kind of
Together, yes,
They were
that's
no
what the
longer
court
together.
decided.
And so one of the things I was just curious about was, and again, I don't know this history at all, you know, left to kind of a lawless, right, environment or landscape, like the choice to kind of still copy or continue like monogamy in some sense,
Yes.
as opposed to it just becoming like lots of polygamy and very informal, relationships that don't have a beginning or an ending and have multiplicity amongst them. Like, you know, why does it lean so heavily toward just copying and trying to mimic what the white
society.
Yeah.
I mean, I think it was that because I know we're at time. I mean, he was part of sort of an more elevated, African American men who were very politically active, and so he enjoyed going to parties. There were, newspaper articles about him and his wives going to parties and being sort of in the social milieu of the time. And so that is what happened, and he very much, wanted to stay in that, and I think he probably needed to be married in order to continue that sort of presentation to society. So I think, that may be a different word choice that I need to put to make, but I think part of the reason why I say that is because of how Black women and men are presented in a lot of the case books, and so it's usually single Black fathers who are not there, or absent, and then women who are single but have many children. and sometimes the fathers are not identified. And so, or it's just a single family, it's not a married family where there are two Black parents. And so I wanted to disrupt, or I think that that case disrupts that stereotype that sometimes comes about not intentionally, but those are the cases that are chosen that are in the family law case books. And so they're generally cases that are basically criminal cases that have a civil code, or civil code issue that has a criminal penalty. And those parents are not married in those situations. And typically there's poverty and race that intersect. And so sometimes if people come into family law and they don't know anything about Black families other than maybe what they've seen on TV or what they're reading in case law, then they get this idea of this is what who Black families are. And I think obviously there's diversity within Black families, but just the fact that once emancipation occurred, Black people got married in droves. They tried to find their people. He didn't try to find Mary, really. I mean, he moved on. So, yeah.
The only other word.
sorry.
We did, so,
Yeah.
20 minutes. I'm gonna give 2 minutes to Rose, additional comments. So the person in green, I think, had a
Yeah,
question
I'm
for
just
Rose.
curious. I like the approach of telling the stories, but I'm wondering if you could just say a little bit about the scope of the problem that you're of this sort of separation problem that you're talking about.
So the question, I think, what is the question that I'm trying to answer here? Well, the question, the broad question is, should immigration and citizenship law be thought of as part of the family law canon? And the answer to that, I'm trying to say in the book, is that yes, it should be considered because, and I'm not the only one who have said that. There's Kristen Collins and Carrie Abrams. But my focus is on Asian American mixed race families. And so when we center immigration and citizenship law within this larger question about what family law means and how it affected them, then I think it shows a little bit more how the work that immigration and citizenship laws did to try to stop interracial families from Japan. And there's another article about Korea and then the Philippines, how those family formations did not happen. And then that led to the inability of some couples to get married because of these military policies, led to children being considered, quote, illegitimate, which then made it hard for them to become considered as US citizens. So that's part of why I'm interested in this question, because family law regulates, determines who is a family, who is a parent and a child, and what benefits come with that. And I want to show how immigration and citizenship law has shaped the regulation of the families on a cross-border perspective.
So for my 18 minutes, I'm gonna try to do mine in 8 to leave 10 minutes for conversation. So in some ways, my project is probably less well developed than my other 3 co-panelists. I was really pleased when Kaipo reached out to me about doing something about this, which allowed me to revisit some old work of mine that was about race, family, and Americanness. Now, Rose commented that her article from 2011 was so long ago. So this is going back 30 years for me. And in particular, I reflected on it because as I was watching all the stuff along SFFA versus Harvard and North Carolina, the thing that I found missing from the conversation was gender. Gender was just completely absent from the conversation. Now, the standard understanding is that white women have been the primary beneficiaries of affirmative action, and that's long-standing. And even though the case was based on race-conscious affirmative action as practiced by Harvard and North Carolina, I was wondering why there wasn't a stronger voice recognizing that if race-based affirmative action goes away in higher education, what's going to happen to gender-based affirmative action in other areas? Probably, maybe not in higher education, in part because, in terms of the gender demographics of who attends college, I also, am less familiar with specific admissions practices. But what it did is I reflected then on an article that I wrote, presented at a symposium where Neil also presented. This was at the school formerly known as Hastings, now UC Law San Francisco. And the article that I wrote there, her essay was Reverse Racism, exclamation mark. Affirmative action, the family, and the dream that is America. And when I talk about reverse racism with an exclamation mark, in some ways I was writing 10 years in advance of what Chief Justice John Roberts said in Parents Involved about the way to get, the way to stop discriminating on the basis of race is to stop discriminating on the basis of race. Well, my point was, if you're going to address racism, you need to reverse racism. So there's this reparative, remedial dimension already to that. But one of the things that I observed during that time, so this was when in California, it was Prop 209, the proposition with regard to preferences in contracting, education, and third category. And then the other things that were happening in Washington State and Michigan following that. Now, if it is true that white women are the primary beneficiaries of affirmative action, then what accounts for their voting behavior with regard to those propositions? So with regard to Prop 209, 65% of white women voted for Prop 209 to get rid of affirmative action that included on the basis of gender. And so then the thing that I began thinking about or reflecting on was, why would white women vote against their own self-interest? And my hypothesis at the time, and something that I want to return to, is that even though in the United States we tell ourselves that this is about individualism, is it the individual that is the relevant economic unit for purposes of making policy or political decisions? And I began thinking that no, it's actually the family that is considered the relevant unit for understanding and making decisions about what policies should be advanced. Now, in 1987, 99% of white Americans were married to other white Americans. And so then, in the heteronormative context, those families are producing white children. And so then, in that, even though white women might have been the primary beneficiaries of affirmative action, we still know that there was and still is a huge wage gap along gender, so white women and white men, and I won't go into the other sort of specific categories there, but if it's true that white men, even with affirmative action, white women are making significantly less than white women are making significantly less than white men, then if they're thinking about the economic interests of their family, then they're actually better off if they're, at least insofar as they perceived it, if their husbands, white husbands, do better, are not hurt by affirmative action. And they were willing, whether they thought about it in this way or not, to make that sacrifice with regard to their own interests and also the interests of their white daughters, advancing in some ways the interests of their husbands and their sons. And so then, in terms of thinking about this and in terms of identity, so then how do they experience their identity? Is it a gender identity? Is it a race identity? And what we see is, it is an intersectional identity. And so I don't know if you were there yesterday for Russell Robinson's talk, but in the intersectional identity that they're experiencing, it's not that whiteness, it's whiteness and their gender as women. And so I've been, in terms of then reflecting now, thinking about this now, is there something there in terms of revisiting that prior analysis, that prior hypothesis? So then with regard to SFFA versus Harvard and North Carolina and affirmative action more generally, where are white women in this conversation? Are things different because there is more mixed race marriages, which might be producing more mixed race children? How are these things different? And so this is where I'm hoping that, because this is at such an early stage in terms of thinking about this, whether or not this is worth returning to in terms of exploring. And then if it is something that is worth returning to in terms of exploring, then what kinds of questions do I need to ask myself in terms of the family dynamics, understanding all of the way that mixed race marriages are operating, mixed race children, and things like that. But at the end of this, the sort of bigger picture part of this includes that when we're thinking about family, and if that is the relevant unit, to understand in some ways the way that race and sex are being policed in a way that allows some families to be fully American and some families to never be able to gain that. And that's where I'm just so fascinating with the becoming Japanese or becoming non-Japanese. But I also found it fascinating, Kaipo, that you said becoming non-Japanese, not becoming white. And so...
Well, it's because I'm still trying to work it out, right? Because I'm trying to work out what are the implications of like fitting like Filipinos and Chinese into the category, changing the thing from Caucasian to just like friendly US nation, but keeping the like raising the children in a Caucasian environment. You know, I don't know if it is coherent, but yeah, so I don't know yet.
Yeah, so that's what I have, and so I'm looking forward to you pushing me a little bit on this. Thank you.
We have thoughts from the family law studies.
I know, right?
Yeah. So one thing is there's a rise in interracial marriages maybe since Prop 209, but there's also a decline in marriage rates, and I kind of that, you know, it went down towards almost 50%, and it looked like it was going to go lower, but it's stabilized at around 51% of households are married. But so it's probably still a noticeable decline since you thought about this earlier. So that would be a way of testing the hypothesis too, because you have these people who may vote in a similar way, but they're not going to benefit from a marital sort of situation, and so other things would explain what's going on. And then also there's a rise in singlehood studies, and so it'd be interesting to see the impact of people who, like, does that have any? I don't know if it would, but yeah, I think that in addition to like more cohabitation, there's also more intentional single households, so that could fit in.
Well, I had some different thoughts. I was thinking about sort of the reinscribing of coverture, just thinking about, you know, how laws are going backwards, and as far as like the, you know, Dobbs getting rid of abortion, and so eliminating women's choice in many instances. And so there were commercials that came out during the election of white women, you know, going to the box and sort of like, well, if, you know, your husband doesn't know what you're gonna vote, and so kind of like giving them permission to vote differently than what their spouse was telling them apparently to vote, or sort of you have to vote the way the family votes versus, or the way I say vote versus your own vote. And so to me, it seems like a reinscribing of white women being subsumed under marriage, or at least seeking to marry white men in certain instances, and that they vote along the line of whatever their husband votes, because that's in their best interest and the best interest of their children, at least from their perspective. So to me, I remember when I went to a Women in Legal Education conference last year, and they talked about how women are actually, we make up more than 51% of the law schools, like overall. I don't know what the breakdown is with respect to race, but there may be a presumption that it will not affect them, because if the people in charge are or in power actually are white men, then they may or may not look out for the people within their family. But even if they don't, from a financial standpoint, they will be aligned with the person in power who is a white man. Yeah.
I think Leo hasn't spoken yet, so we'll go.
So about Bob's project, I'm fascinated about the question about like why white women are not in the common scholarly or just regular discussion about why they would not support some initiative, some program that will benefit them. Then I think about it, but it happens all the time. Right? Voting against your own interests is a thing. It's very common. It happens all the time. I think one easier way to understand it is because the message, right? The message is always going to wrap to a voter in certain fashion, not on the true merit of it. And no politician would present something in miracle study format, right? See, this is good for you numbers, right? And then it will very often racialize into some sort of message and present it to you. For affirmative action, the racialized message is usually anti-black, right? So that is really the core of the message. Do you think that is a way to understand white women's certain position towards affirmative action, as this is not something about them, it's about anti-certain community, that it goes back to a lot of initiative of, I think there's some studies saying that white women voted for Trump overwhelmingly in many communities, but really what kind of campaign Trump was running, that's anti-woman. The abortion situation was very anti-white women specifically. Do you think that is a channel to understand that dynamic as well?
No, that's really helpful. So in terms of thinking more broadly about, what is it that motivates people to vote in certain ways, and I think I need to think a lot more deeply about that, so I appreciate your question. The woman in green.
Yeah, just to follow up on that, it sort of as an empirical matter, I guess, how do you control for just white women being racist and or internally misogynistic, right? Like there's this whole trad wife movement going on right now, which is especially in white communities, right, where women are choosing to or think of the male member of the household as superior, right? And so I just wonder how either in the original project or in the project you're considering now, how do you actually say this is what the motivator is when often, women are complex.
Thank you for that.
So my question sort of requires Jessica's commentary on this, because I wanted to ask about why, I know what the case says about why they didn't allow enslaved people to be married.
Mm-hmm.
Yes, they gave all the reasons. But they seem like bullshit to me. It feels like there's something else behind that. And I think that's also going back to this idea that I believe, and I'm interested in what you guys think, that marriage at some point, and maybe now, was or is a mechanism to preserve whiteness. And so if we're talking about it in the family law space, particularly your piece, I kind of want to push back on this idea that white women share an intersectional identity, considering that the protection of whiteness sort of envelopes everything, all like the womanness, all of that. I think that I want to hear what you think about that pushback, because I think when you said it, it felt like a gut punch for me. It just didn't sit well in the way, and obviously it's not your words, right? There are people who have espoused this, but I think thinking about the role of whiteness, particularly in preserving family and marriage in the United States, is going to be really important in figuring out why white women vote the way they do, or sort of make choices that go against their womanness, or whatever their gender is. And I think it's because whiteness is what is the umbrella for them in all spaces, whether we're talking about affirmative action or women's, pregnancy rights, or those kinds of things. So
I just want to add something to what you said. You said, marriage is about the preservation of whiteness, and I would add inferiority to that, because I think it was the late Judge Higginbottom that talked about precepts of inferiority. And he goes through a book that talks about shades of freedom and goes through a lot of different cases that basically, showcase how these precepts of inferiority are demonstrated by case law. And I think marriage is one of those things it was held in a very high esteem. You had to be moral, you had to demonstrate fidelity, you had to be learned, I think, intelligent. And so all of these things were not what the enslaved person was with respect to stereotypes and how they inscribed enslavement for blacks particularly. And so if you think about marriage as the inscribement of both whiteness and inferiority or superiority, the flip of that, then that tracks with what he's trying to say. And I see why you're saying it's a gut punch, because really white women were sort of the shadow beneficiary of affirmative action. It was really intended for minorities and underrepresented persons, but it ended up benefiting white women who were they were underrepresented, but they still shared whiteness with the men. And so they were, I think it aligns with the similar statements that white women said at the time, like they were like slaves in marriage. And enslaved persons were like, no, you weren't. It's not a good comparison. So, I think it tracks the same thought pattern.
Yeah, so what that made me think about was, the way that different identity axes can be activated. So Jerry Kong talks about this elegant experiment with math and Asian American women. So math tests and Asian American women. So when the women are asked a question that activates more their gendered identity, they underperform. If they're given something that activates their Asian Americanness, they overperform. And so then it's interesting then thinking about, well, is it intersectionality not really the right mode, but rather what is it that's being activated? And so with regard to affirmative action, because it gets coded as race, the thing that gets activated for them is their racial identity without even thinking maybe about gender. And so that's helpful for in terms of thinking about it in that way. Thank you.
It's
3:02.
Oh, okay.
What is the type of thing just like
We're thinking about it.
we're thinking about it, like household, individual, like it could be household, it could be individual, it could be family, it could be identity group.